The ancillary certificates to be provided are the next step to be considered. It is the role of the assigned certifier, in conjunction with the assigned builder, we covered this in video 2, to identify all design professionals and specialists from whom certificates are to be required. It is the assigned certifier's role to identify all certificates and obtain them, if and to the extent that the builder is required to provide ancillary certificates or procure those at pre-contract stage prior to commencement, say for the design. It's very, very important that that's actually included in the contract conditions. So the main contractor, the assigned builder, can actually understand this is something that I have to be able to provide, and therefore when I go to engage the supply chain, I need to be able to put that into their contract of works and their specifications so that they know that that's something they have to provide to be compliant with the contract conditions. There's no point 60% of the way through a project deciding, I think it would be good to get design certification for this element of works because you think it would be prudent. If someone hasn't been engaged on that basis, and particularly if it hasn't been set out at the very commencement stage for the assigned builder. It's prudent for the contractor assigned builder to set out a schedule of ancillary certificates, confirming the packages that they will actually apply to and their format. For example, the CIF 01 or what's known as the CS certificate. And if this list has not been specifically provided or agreed with the assigned certifier, to send it to the assigned certifier and to confirm this is the basis upon which I'm approaching the contract. This is the suite of certificates that I'll provide. Here are the packages. Here are the subcontract packages that I've already awarded. And here's the form of certification that I'll be providing from each of those. So there's no ambiguity as to one or other certificates. It's very clear that it's either the CIF CS or the CIF CSS certificate that will be provided by those specialists as ancillary certifiers. As stated above, the CIF, the RAEI, the ACEI, Engineers Ireland and SCSI have agreed a standard set of practice notes to support the requirement to provide ancillary certificates to be used by subcontractors, specialists and subcontractors. The contractor or assigned builder should seek to avoid being contractually bound to provide certification beyond what's contained in the agreed forms and also what's agreed within the practice notes. My advice would be to always start with practice note 1 and to look at the principles that are contained therein, because that really sets out the project parameters and the parent kind of approach to looking at whether or not someone is a CS certificate or perhaps one of the other certificates. The contractor or assigned builder should make themselves aware of the content of the practice notes as agreed by all the professional bodies and the CIF. The provision of SD certificates is quite a contentious area, and this is the area I want to cover next. SD certificates of compliance for design specifically relate to the commencement notice, and its form actually certifies that the proposed design for the elements that the certifiers are responsible for complies with the building regulations. SD ancillary certificates relate to the design of the works rather than as constructed works. In practice note number 1, which I've just referred to previously, as agreed between the CIF and the professional bodies, SD ancillary certificates are required to be signed by competent persons that are specialists, such as perhaps a facade designer, fire systems designer, lift specialist, for their design at design stage and at completion stage. The industry agreed practice note, particularly number 2, sets out that only in a situation where a party is appointed by an assigned builder to undertake design work only, and I stress design work only, then that party would sign an ancillary certificate of compliance, design, SD or SC as appropriate. That's really, really important because they are effectively for specialists providing design work only. As detailed in practice note 2, in all other situations, the assigned builder or subcontractor is only required to provide a CS or CSS ancillary certificate. The design representation made in the SD certificate goes further than the warranty and representation made under the CS, CSS certificates outlined above. To understand the different level of warranty and risk involved when providing SD certificates, it's really important to assess the language used in the standard form of SD certificates to understand what's actually been asked of you there and actually to look at it, to read it in plain English and see, does this make sense? Am I actually being appointed just to provide design work only? Am I actually providing construction or installation works with associated elements of design? and that allows you to determine which of the appropriate certificates you should be looking at. The SD certificate is essentially a representation or warranty from the certifier in respect of design. And if you think about that, that's where you've got to stop and think, am I primarily only being appointed for design works only? Of particular importance are clauses 4, 6, 7 and 8. In that standard form of SD certificate, each of these clauses are detailed in the attached slide. If a contractor or assigned builder has contractually agreed to provide any form of ancillary certificate, particularly SD ancillary certificates, outside of the industry agreed practice notes 1 and 2, they should satisfy themselves that they've indeed done so and can warrant what they're signing up to. Do not enter any process outside the standard certificates unless you have been given professional advice as to what risk you're actually signing up to and can you actually certify that process, whether it be design, works, inspection. It's really, really important that you understand what that document, if it's off standard. There are serious risks involved if an inappropriate ancillary certificate is issued by a contractor, assigned builder, because it could be relied upon by others just beyond just the architect. It could be assigned to other parties, particularly in development agreements where there might be assignment to investors, funders or potential future tenant purchasers of units that are being built. The provision of an RIAI ACD SD ancillary certificate under the industry agreed practice note is limited to a very specific circumstance involving only the main contractor or assigned builder. It's therefore critically important that by default the standard CS and CSS ancillary certificates are used in the appropriate circumstances and that the wording in the certificate conforms with what has been done and avoids the potential risk of negligent misstatement. The primary position to remember, if you're involved in an employer design contract, it is almost 99.9% a position of certainty to sit in that you can say you're not really been asked to design works. It's an employer design contract. The flow of design, parent design, design performance, primary design rests with the design team. So it's very, very unlikely that you're actually going to be also given a separate conditions of engagement for design package. It's going to be something that's associated with an element of your works, a package of works. There will be an associated design responsibility that you'll use the CS and CSS certificates to set out in the Annex Part 2, and we'll cover that again in a second. It's therefore really critically important that people understand that by default, the standard CS, CSS ancillary certificates are used in appropriate circumstances and that the wording in that certificate conforms with what work has been done and avoids a potential risk of a negligent misstatement. The main contractor or assigned builder should also understand what level of design responsibility they have been asked to take on, what they're expected to pass on to their subcontractors in terms of design, and to be aware if they're providing ancillary certificates to the employer or building owner. If these contain any negligent misstatement, the contractor or assigned builder could potentially be liable as well. Any obligation to provide ancillary certificates in respective design elements should be notified to the assigned builder's insurer or broker to ensure the PI cover is in place and extends to the issue of such certificates. Again, for the purposes of clarity, it's really important to understand that ancillary certifiers traditionally should only be asked to provide certificates in the form of the CS, CSS, particularly when they flow through the main contractor or assigned builder. These allow for the certification of associated design works completed by those sub-specialists in their Annex Part 2, only where a specialist is engaged with conditions of engagement to complete specific design works and has agreed or will agree to provide another form of certificate should this be agreed to, particularly at commencement stage. Where there's any ambiguity, the contractor or assigned builder should at the initial project stage with the assigned certifier agree the schedule of ancillary certificates, the format that they'd be provided in, with the CS, CSS being the default, and the specific specialist or sub-specialist packages to provide such certificates. Our advice would be, where there's ambiguity, where there's a lack of information, you set out what your understanding is and you provide them with a schedule of what you're prepared to provide so that there is at least a position of clarity at some point in the contract flow of information, and at that point in the project at least you have an understanding of what should be provided. Whether or not that changes, then you can measure that change, and particularly measure your ability to actually comply with anything else that's required by an assigned certifier as the project actually proceeds. In an employer design contract, again, I would stress it's really, really important that you're advised to seek out the design responsibility matrix that sits with the CIF Building Control Amendment Regulations, this guidance note on design risk and BCAR. And that design responsibility matrix should help you understand what has been designed, what's left to be designed, and what subspecialist packages there's an expectation on you to price and agree to take on some degree of design responsibility or perhaps design coordination in those packages. Thank you very much.